NI High Court, Lidl wins licensing battle over plan to open first-ever in-store pub delivering judgment for the High Court. Mr. Justice Adrian Colton remarked that while the concept of a licensed premises attached to a supermarket is undoubtedly a new development, the restrictive nature of the 1996 order does not mean that it prevents innovation and development of new ways to run licensed premises. Stuart Beattie KC appeared for the applicant/respondent, instructed by DWF, NI, LLP. Liam McCullum KC with Richard Shields appeared for the objector/appellant, instructed by Mills Seelig. Background: the respondent was provisionally granted a license for its supermarket premises in Dundonald for the sale of intoxicating liquor by retail for consumption either on or off the premises as provided for in Article 5(1)(a) of the Licensing, Northern Ireland, Order 1996. An objector appealed on the basis that the respondent failed to establish the inadequacy as to the number of licensed premises in the vicinity of its premises as required by Article 7(4)(e) of the 1996 order, and that the application was essentially an application for an off-license with no serious intention of offering an on-sales facility and was an impermissible attempt to circumvent the 1996 order. The High Court Mr. Justice Colton was satisfied that having regard to inter alia, Lidl, NI, GmbH v. Winemark The Wine Merchants Ltd., 2008, NIQB 146, the court was required to ignore the contribution of the subsisting license of Ruby's, which was proposed to be surrendered, to the satisfaction of demand in the vicinity of the premises. In this regard, the judge noted, if the application is granted and the license subsequently issues, the subsisting license will not be trading within the vicinity. Thus, it cannot possibly contribute to the satisfaction of the demand in the vicinity upon which the applicant relies to support the application. The court moved to consider whether existing off-sales premises should be included in assessing inadequacy, in circumstances where it was argued that the only premises that would be impacted upon by the grant of the application were off-sales providers. Observing that there is no case law on this point, Mr. Justice Colton highlighted having regard to the wording of the 1996 order, a public house/on/off sales license is different to an off license and thus are not premises of the kind specified in the application, for the purposes of Article 7(4)(e)(i) thereof. The court was satisfied that the respondent easily established inadequacy in circumstances where inter alia research carried out in October 2019 reported that 10% of those surveyed identified the need for more pubs in the area. Mr. Justice Colton outlined that the proposal will provide a public house facility that is located within the commercial/retail and transport hub of the vicinity and where significant numbers of people are attracted daily from within and from outside.